Hello, this is Matt on the Moon Lambo channel, and here's a brand new piece from Finance Feeds titled Ripple Stands to Win Battle Over Fair Notice Amid SEC's Backfire. And Ripple has filed a brand new document defending the fair notice defense, but not even fair notice defense, just the fact that from their perspective, and I certainly do believe they're right, that they should be allowed to defend the fair notice defense. So understand what's at stake here immediately anyway is not the outcome of whether or not in fact Ripple did have notice from the SEC, fair notice from the SEC that what they were doing was illegal. It's whether or not they're even allowed to argue that in court. And this probably is Ripple's last chance to defend that case. There could be, but there won't likely be additional documents filed on this topic before Judge Torres puts out her official ruling on whether or not Ripple can even use this defense in court. We don't know exactly when it's going to be, but I think it was from Jeremy Hogan, Attorney Jeremy Hogan. I could be mistaken, but I think I recently saw something from him where he was saying it might be, I can't remember if he said this month or next month, but either way, that ruling is going to come down sooner than later. So I want to run through this and share with you perspective, including what Jeremy Hogan had to say, because I'll tell you right here at the outset, he does think that this defense will stand, that Ripple will have the ability, after the judge's ruling, to argue their fair notice defense, and then we'll have to see whether or not that stands by the time this court case is finished, but Jeremy Hogan does think that he'll be able to they'll be able to argue that, which is really of crucial importance, because the implications of that are huge. Just imagine, because if you're the SEC and there's a chance that the court might find that you didn't give fair notice to Ripple, then you didn't give fair notice probably to pretty much everybody else in the space that you want to sue into oblivion, because there is a lot of overlap. There is something in particular highlighted in the SEC versus Ripple case, though, that is unique relative to other enforcement actions that the SEC has brought. But in terms of fair notice, that would apply to pretty much every other cryptocurrency on the planet, just about. I mean, tons of them, right? But I do want to be clear at the outset, I don't have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto topics, but just as a hobby and just for fun. In we go, folks. Ripple has filed its surreply regarding the SEC's motion to strike the fair notice affirmative defense to oppose the SEC's inappropriate request for judicial notice and to address the SEC's misleading characterization of its prior enforcement actions. The SEC has previously asserted that Ripple's fair notice defense fails because prior to suing Ripple, the SEC had already brought more than 70 cases that subjected other digital assets to the application of the federal securities laws. Well, let me just pause there. That sounds really powerful. Oh my gosh, the SEC had sued other businesses and people? Oh my gosh, under federal securities law? This is under federal securities law? It sounds like the same thing. No, it's not the same damn thing, and you'll see why as we go through this. There's something about this case in particular that is extremely unique in fact, and the SEC just wants to clump all of their enforcement actions, no matter how unrelated, together. They want to pretend as if it's exactly the same or sufficiently close. Folks, it is not. Anyway, piece continues. The agency also cited the May 2021 report by Cornerstone Research, distributed after Ripple filed its opposition brief, and requested the court to take judicial notice of the SEC complaints, which the report characterizes as cryptocurrency enforcement actions. That's pretty broad, don't you think? Cryptocurrency enforcement actions, that's kind of a broad banner to fly under. Yeah, and you'll see why that matters. We're coming up on it right now. There's this little subheading, 70 plus enforcement actions support Ripple, not the SEC. In response, Ripple stated that a surreply is amply justified here. In order to tackle the SEC's this is a quote, by the way, the SEC's inappropriately premature request for this court to conclude as a factual matter that market participants had fair notice that XRP would be considered a security, end quote. And the piece continues. The enforcement actions cited in the report do not actually support the SEC's argument in the first place, the Ripple counsel argued, adding that, quote, not one of those cases alleged a violation of Section 5's registration requirements for a sale of digital assets outside the context of an ICO, End quote. So now think about the implications of this. Because look, the SEC, by the time 2017 was rolling around, they were publicly speaking about the danger of ICOs and how really pretty much all of them probably illegal. And that's what the SEC was focusing on. That's the market guidance, if you want to call it that they were offering at the time, effectively. Well, there was no ICO for XRP. Didn't happen, didn't exist, period. And so given the confusion in the marketplace and the uncertainty and mixed messaging, all sorts of things, if you're Ripple, how the hell do you know what the SEC thinks? You're not a damn mind reader. And then here's another quote from Ripple. The court should deny the SEC's request for judicial notice and disregard the SEC's attempt to rely on disputed facts to foreclose a legally cognizable defense, end quote. And so think about what's at stake here. It's whether, like I said, it's whether or not Ripple should be able to even argue this defense. And given how this isn't exactly open and shut here, it only stands to reason that Ripple should be able to defend this position in court, and then the judge can determine whether or not it's a reasonable argument. But they should be able to argue it. Of course they should. There's too much disputed here for this to just be broomed, to just be thrown away. Piece continues. In conclusion, Ripple argues that the court may not properly take judicial notice of the Cornerstone report. The facts it contains are not undisputed, and if the court were to consider the cases cited in the report, they support Ripple, not the SEC. And take a look at this. This is a screenshot of Exhibit A, and they note the following. Exhibit A is a list of 75 cryptocurrency enforcement actions covered by the Cornerstone report, dividing each action by 3 categories. And they're here where I'm circling. If you're looking at your screen, you can see where I'm circling. These are the 3 categories. The first category is alleged unregistered sale of securities. The second category is based on sale of digital assets. And then 3, outside the ICO context. And out of all 75 listed, and the SEC versus Ripple case is just one of the 75, out of all of them, there's only one case that checks all 3 boxes, and that is the SEC versus Ripple case, which is highlighted here in yellow at the bottom, where I'm circling right here. It's the only one that has, again, alleged unregistered sale of securities, also based on sale of digital assets, and also outside the ICO context. It's the only one on the entire planet. So the SEC here, they're just broadly clumping together everything and pretending like, see, look at these other enforcement actions. It's all the same. Yeah, whatever. No, it's completely ridiculous and absurd. It's not logical. But like I've said many times over the course of the last years we've been covering this case, the SEC, they're not making arguments that make logical sense. They're just throwing everything out there and just seeing what sticks. They're seeing if they can pull a fast one over the judge. That's what it looks like to me, and I do mean that. It looks to me like, because their arguments are so garbage so much of the time, it seems to me they're just throwing it out there and hoping that it'll just get past the judge, or the judge will happen to agree. And these judges, they're not stupid. Judge Netburn and Judge Torres, they're clearly intelligent individuals. I don't see them falling for all this, but I guess the hope is that you just throw enough out there that even if it's like less than 1% of the stupid arguments you make that the judge falls for, maybe that's enough to help you in some sort of meaningful way. That's what it looks like. That's how bad this is. It's completely ridiculous. And then there was this separate article. I don't really want to read through this, but it's noting a comment from attorney Jeremy Hogan, which I'll just summarize it here. We don't need to actually read this article here. The point in this that I really wanted to bring home was that Jeremy Hogan does think that the fair notice defense will be allowed, which again is a separate issue from whether or not the judge will find that Ripple did or did not receive fair notice, but he does believe that it will be allowed as a defense in the court case. That is what he's thinking. And he also thinks that the charges won't be dismissed against Brad Garlinghouse and Chris Larson. So we'll see. And the charges against Brad Garlinghouse and Chris Larson, that's actually another thing worth mentioning too. It was covered in this first article here. I think it was anyway. I've read a lot of articles, but as far as Brad Garlinghouse and Chris Larson, which it's so absurd that they're even named as defendants specifically in this case in a non-fraud case. That's pretty much unheard of. That is not within the legal precedent. This is not what you'd expect to see, but they're doing that because the SEC, they're just being bullies. But it's interesting because What's publicly known to this point is that either 100% or very close to 100% of Chris Larson and Brad Garlinghouse's sales of XRP actually occurred outside of the United States. That's highly relevant. Why? Because the SEC doesn't have jurisdiction regarding sales that occur outside of the United States. So the SEC is nothing but an incredible uphill battle in front of them, and that's, I think they just seem desperate, and the case is weak. They're really desperate here. They did not have their ducks in a row before they filed this. I guess they're just so used to being able to bully everybody into submission that what would they think, that just like all the other firms, Ripple was just going to acquiesce and then that was it, and just be like, okay, big old SEC, we were wrong. Well, here's the fine, blah blah. No, Ripple's fighting back because they have quite the war chest out there in terms of for those of you that missed it, there's news within the last couple of weeks or so. Ripple literally has $1 billion on its balance sheet. $1 billion in the bank. I'm not talking about their XRP holdings. I'm talking about they have $1 billion. And so most firms, if they were to fight the SEC, even if they win, they'd go bankrupt. So it's like a shallow victory in that sense, but not Ripple. So they're coming at them here. It's ridiculous. And then here is this also. This is a tweet from attorney Jeremy Hogan. He wrote, "The SEC argued that prior lawsuits against crypto companies provided fair notice to Ripple. However, half of the lawsuits did not involve sale of any digital assets at all, and the other half involved companies that held ICOs. And, oh yeah, the first lawsuit was in 2017, so, ... So, folks, think about that. Half of them, they're using this as defense, half of them had nothing to do with cryptocurrencies. But still, it was under federal securities law, so because reasons, it makes sense, they say. No. And then when you're talking about fair notice specifically, the first of these lawsuits was in 2017. So how was Ripple then supposed to know back in 2013 that what they were doing was illegal? Because again, the argument is that there was or was not, depending on which site you're talking about, was or was not fair notice. And so given the uncertainty here and all of this and the fact that their evidence doesn't even apply to the entire timeline, why would this defense not be allowed to proceed? Just for Ripple to be able to make the argument. Don't make no damn sense to Moon Lambo up on this bitch. But I'll wrap up there. Let me know what you think. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo.